December 22, 2025. Court documents show a Baltimore jury takes 1 day to decide. 1 day to calculate the value of a human life destroyed by a product that promised to protect it. 1 day to determine what a mother of 5 is worth when a corporation decides profit matters more than safety. The verdict, $1 billion, plus $500 million more, plus nearly $60 million for her medical costs. Total, $1.5 billion. Her legal team calls it the largest sum ever awarded to a single victim in Johnson & Johnson's 140-year history. The plaintiff, Cherie Craft, 54 years old. Court records describe her as founder of Smart from the Start, a nonprofit helping traumatized children and families. Mother of 5. In January 2024, trial testimony revealed she received a diagnosis, peritoneal mesothelioma, an incurable cancer caused by asbestos exposure. Her lawyer would tell the jury her cancer was preventable. The product that killed her, the jury found, Johnson's baby powder. The substance that poisoned her? Asbestos. The question the jury had to answer: did Johnson & Johnson know? The answer, internal documents dating back to 1957 presented at trial showed, was yes. Court records confirm they knew. They tested, they found contamination, and they sold it anyway. For decades, to mothers, to babies, to families who believed the label when it said pure and safe. This is not a story about a defective product that slipped through quality control. Evidence presented at trial tells a different story, one about a corporation that calculated the cost of human life against the cost of pulling a billion-dollar product from shelves and chose the product, every single time. But here is the question the verdict does not answer. If they were willing to hide asbestos for 70 years, what else are they hiding? And if it took a 54-year-old mother dying of cancer to get a jury to say $1.5 billion, how many others are still out there, silently sick, not knowing why? This is Case File, the $1.5 billion sentence. Part 1. The Trusted Product. For most of the 20th century, Johnson's baby powder was more than a product. It was a ritual. Mothers dusted their babies after bath time. Women used it after showers. It sat on bathroom shelves in hospitals, nurseries, and homes across America. The bottle was white and pink, with a picture of a cherubic infant and a promise, clinically proven mildness. Johnson & Johnson built an empire on trust. They were the company that made Band-Aids and Tylenol and baby shampoo that promised no more tears. Their baby powder was not just safe, it was iconic. Company financial records show that by the 1980s, it was generating $400 million in annual revenue. Market research indicates that globally, over 90 million women used it regularly. Trial testimony established that Cherie Craft was one of them. Born in 1971, she started using Johnson's baby powder as a child, every day, on her body, in her shoes, after every shower. It became part of her routine, so automatic she did not think about it. It was just baby powder. What could be safer than a product designed for infants? Her testimony revealed she used it for 53 years, from 1971 to 2024. 53 years of daily application. 53 years of microscopic talc particles entering her body. And buried in that talc, invisible to the naked eye, were fibers of asbestos, needle-like minerals that, once inhaled or absorbed, lodge in tissue and never leave. Asbestos does not kill quickly. It waits. 10 years, 20 years, 30 years. Medical experts testified it hides in the lining of the lungs, the abdomen, the organs. And then, decades later, the cells begin to mutate. Scar tissue forms. Tumors grow. By the time symptoms appear, it is often too late. In January 2024, medical records presented at trial show Cherie Craft was diagnosed with peritoneal mesothelioma. Medical experts testified that it is a rare cancer. It is incurable. Clinical data indicates the 5-year survival rate is less than 20%. The cause, every medical expert who testified in her trial concluded, was asbestos exposure from talc-based cosmetic powder. Court records describe her life before cancer, 5 children, a nonprofit helping traumatized kids and families, decades of service to her community, and now she had cancer, caused by a product she trusted since childhood, a product that promised to keep her safe. But Johnson & Johnson would argue in court, their legal team stated, that they did not know, that the asbestos contamination was unforeseeable, that they were victims of bad science and greedy lawyers. The jury would hear a very different story from the documents presented. Part 2, they knew. The most damning evidence in Cherie Craft's trial, legal observers noted, was not expert testimony or medical scans. It was Johnson & Johnson's own documents, internal memos, laboratory reports, corporate correspondence spanning 7 decades, and trial testimony showed those documents told a story the company desperately did not want the jury to hear. Internal documents presented at trial reveal that in 1957 and 1958, Johnson & Johnson ordered tests on talc they were mining in Italy. Test results showed contamination, asbestos fibers mixed with the talc. Investigative reporting by Reuters, later confirmed by Senate investigations, found that the company's response was not to warn consumers or pull the product. Documents show those test results were not included in official company records provided to regulators. Evidence from the 1970s presented at trial showed the FDA and independent researchers began raising alarms about talc safety. Studies linked talc to respiratory issues and potential cancer risks. Internal memos revealed Johnson & Johnson scientists conducted more tests. Some found asbestos. The company continued selling baby powder without a warning label. Product packaging from that era confirms. A 1976 internal memo uncovered in litigation and presented at trial discussed the problem of asbestos in their talc supply. Court testimony analyzing the memo showed it did not propose removing the product. It proposed better public relations. Court records document that lawsuits began in the 1990s and 2000s. Women with ovarian cancer, workers with mesothelioma, families of the dead. Every case brought more documents into the public record. Legal experts testified that every document showed the same pattern. Johnson & Johnson knew about potential contamination, but calculated that the cost of liability was less than the cost of abandoning a billion-dollar product. 2019. The smoking gun. FDA records show the agency itself tested a bottle of Johnson's baby powder, purchased off a retail shelf on October 18, 2019. The FDA's official report confirmed chrysotile asbestos fibers detected. Company statements announced Johnson & Johnson recalled 33,000 bottles from that batch. News reports confirmed they did not issue a nationwide recall. They did not pull the product globally. In their statement, they called it an abundance of caution and insisted the overall product was safe. 2023. Company announcements revealed that after decades of lawsuits, mounting verdicts, and a failed attempt to use bankruptcy to cap liability, Johnson & Johnson finally stopped selling talc-based baby powder globally. But their official statements maintained their position. The product was always safe. The asbestos claims are junk science. The lawsuits are driven by greedy lawyers, not legitimate victims. Court records show Cherie Craft's legal team presented this timeline to the Baltimore jury. They presented the internal documents. They presented the FDA findings. Testimony revealed they asked, if Johnson & Johnson did not know their product was contaminated, why did they spend 70 years hiding test results? News reports indicate the jury did not need long to decide. 1 day of deliberations. The verdict, court documents confirm. Johnson & Johnson was negligent. They failed to warn. They deceived the public. And they were responsible for Cherie Craft's cancer. The punitive damages, $1.5 billion, legal experts explain, were not just compensation. They were punishment. A message from 12 ordinary citizens to one of the largest corporations in the world. You do not get to poison people for profit and walk away. Part 3, the Texas two-step. For most companies facing a billion-dollar verdict, the path forward is clear: appeal, settle, or face financial ruin. Legal experts note Johnson & Johnson chose a fourth option. They invented a legal strategy so audacious that critics gave it a name: the Texas two-step. Here is how it works. Bankruptcy court filings show Johnson & Johnson, one of the most profitable pharmaceutical companies in the world, a company with a market cap exceeding $400 billion, creates a subsidiary called LTL Management. Court documents reveal they transfer all of their baby powder liabilities to that subsidiary. Then the filing shows they immediately declare the subsidiary bankrupt. The result, legal analysis indicates, all the lawsuits get frozen. The victims are forced into bankruptcy court, where their claims are capped and their leverage disappears. Meanwhile, Johnson & Johnson, the actual company, the one with all the money, continues operating, untouched. Legal scholars describe it as a loophole, a shell game, a way to use the bankruptcy system not to reorganize a failing business, but to avoid accountability for mass harm. Court records document they tried it in 2021. A federal judge rejected it. News reports show they tried again in 2023, rejected again. Recent court filings reveal they tried a third time in 2025, this time offering a $9 billion settlement to resolve the pending lawsuits. The bankruptcy judge's ruling found it insufficient and dismissed the case. The Texas two-step had failed, legal observers concluded. And now, current litigation status shows, Johnson & Johnson faces what they tried to avoid: tens of thousands of individual trials. Each one a chance for a jury to hear the evidence. Each one a chance for another billion-dollar verdict. Court testimony established Cherie Craft's case was one of those trials. Her lawyers told the jury, closing argument transcripts show, Johnson & Johnson made a choice. They could have warned consumers. They could have reformulated the product. They could have pulled it from shelves. But every one of those options cost money. And so the evidence demonstrated they chose silence. They chose profit. And they chose to let people like Cherie Craft, a mother, a nonprofit leader, a woman who spent her life helping others, get cancer from a product they knew was contaminated. The verdict confirmed the jury agreed. Court documents show they did not just award compensatory damages to cover Cherie's medical costs and suffering. They added punitive damages designed to hurt. $1 billion against Johnson & Johnson, $500 million against their talc subsidiary. The message legal experts interpret: if you poison the public for decades and then try to use bankruptcy to escape justice, we'll make sure you feel it. News reports confirm Johnson & Johnson immediately announced they would appeal. In their statement, they called the verdict excessive and unconstitutional. Their official position maintains that decades of scientific studies prove their baby powder is safe. But court records show the jury saw the internal documents. They saw the 1950s test results. They saw the 2019 FDA findings. They saw 70 years of evidence. And their verdict called it what it was: negligence, deception, and corporate greed. Litigation tracking as of January 2026 shows over 67,000 lawsuits remain pending. Legal observers note each one represents a person who used baby powder and got sick. Each one represents a family that trusted Johnson & Johnson and lost someone they loved. Court records confirm Cherie Craft's trial is over, but legal experts agree the larger battle is just beginning. Conclusion: the cost of trust. As of today, company statements confirm Johnson & Johnson has not admitted wrongdoing. Their official position maintains that their baby powder was safe. They point to studies, many funded by the company itself. Disclosures reveal that claim no link between talc and cancer. Their legal team argues that the lawsuits are driven by litigation mills, not science. But court records show the juries keep ruling against them. California, Minnesota, Baltimore. Billion-dollar verdicts piling up like the bodies of the people their product killed. And legal analysis indicates every verdict reveals the same pattern: internal knowledge, external denial, and a calculated bet that they could keep the truth buried long enough to outlast the victims. The broader question is this: How many other products are sitting on our shelves right now, hiding the same secret? How many other companies have run the same cost-benefit analysis, weighing the price of human life against the price of lost revenue, and made the same choice Johnson & Johnson made? Because business ethics experts observe that is the real lesson of the baby powder scandal. It is not that corporations are evil. It is that they are rational. They calculate risk. They calculate profit. And when the numbers say that hiding the danger is cheaper than disclosing it, regulatory failures allow some of them to choose silence every single time. The only thing that changes the math, legal scholars conclude, is accountability. Verdicts like Cherie Craft's, juries that refuse to let billion-dollar companies buy their way out of responsibility, and investigators, journalists, lawyers, whistleblowers who dig through the archives and expose what was buried. This has been Case File, the $1.5 billion sentence. The next file is already open. The next vault is already waiting. Subscribe to see what we uncover next, because the truth is always there. It is just a matter of who has the courage to find it and the platform to share it. Thank you for watching.